For the next 30 minutes, you have a chance to call the law. Keith Williams and Don Higley are here to answer your criminal and civil law questions. Call now, 561-TALK. That's 561-8255.
Call the Law. I'm your host, criminal attorney Keith Williams, and with me is my co-host, civil attorney Don Higley. We're here every Tuesday night from 6:30 to 7, live on the radio, 103.7, the source for talk, news, and information, and live on the TV, Greenville's Cable Channel 7. This is your chance to talk to a lawyer for free, to learn everything you always wanted to know about the law but were afraid to ask. We invite you to call us at 561-TALK. That's 561-8255, and join the conversation. Don, no announcer this week.
Yeah, that kind of threw me off.
Our professional announcer, Michael Stewart, has the week off, so we had to stand in tonight.
Yeah, you do a good job with it, too, though.
Well, I get paid a lot more than he does just to do that.
Yeah, that's right.
You know, Henry, he cuts us a big check, you and me, for doing this show.
He keeps us on retainer just for that purpose.
Almost ready to give up the law practice. It's so good.
Yeah, about ready to retire.
561-8255, 561-TALK. If you have questions about the criminal law for me or questions about the civil law for Don, we invite you to give us a call at 561-8255. We had a rerun last week, but we're live tonight, Tuesday, June 12th. Hope everybody's enjoying the summer. Had to take a rerun last week because Don was out of town traveling to the big city of Greensboro.
That's right, and I listened to the show on the way back. Fascinating.
I hope we were good.
Riveting.
Riveting, that's right. You couldn't.
I had heard it. I'd actually been there, and yet I couldn't turn it off.
Well, we appreciate everyone who's out there watching on Greenville's Cable Channel 7, everyone who's listening on the radio, 103.7, The Source. Many of you come up to us during the week, and we're always glad to talk with you. Thanks to everyone who's watching and who's listening. We invite you to give us a call tonight at 561-TALK, 561-8255. Questions about the civil law for Don or questions about the criminal law for me. We invite you to give us a call, 561-8255. Don, you were at a deposition last week, which is something I don't get to do in my criminal cases.
Yeah, is that what I was doing?
I think that's what you told me. You went to Greensboro to take a deposition, which, as most people know, is going to be a chance for you to sit down with a witness in advance of trial and ask them questions and know what they're going to say when the trial later comes.
Right, yeah, it was deposition of my clients. You're correct. I'm remembering that now.
But in criminal cases, I don't get depositions.
No, you don't, which is not the case in every jurisdiction. I noticed when I watch the legal shows sometimes that they're talking about how they've taken 50 depositions prior to trial.
That's right. I think in the state of Florida, under state law, you can get depositions in criminal cases pre-trial. But under both federal law and North Carolina law, you cannot do depositions unless you can show a significant hardship. So, for example, if I have a witness who's ill or the doctors are giving them 3 weeks to live and trial is going to be 6 months away, I can make a motion to ask the judge to approve a deposition to preserve their possible trial testimony.
Yeah, and that seems counterintuitive to me. Why would they, in the criminal arena where the stakes are so much higher, no matter how much money you've got at stake in the civil action, doesn't seem like it's as compelling as somebody going to jail. Seems like you should be able to take depots, especially of the experts. It's hard to cross them blind.
Mm-hmm. That's right, because in civil cases, you can make requests for discovery to the other side, and they have to answer your questions within reason. But you have a broad range of discovery available to you in a civil case, where in a criminal case, until very recently, under North Carolina law, constitutionally, all the prosecutor had to give you was information that might tend to show that your client was not guilty of the charges, or information that might tend to impeach or attack the credibility of one of the state's witnesses. Until about 10 years ago, there was no requirement that the prosecutor in North Carolina just give you a copy of their case against your client.
Which was a bad rule.
Which was a very bad rule, because it put the prosecutor in the position of having to weigh what's helpful and what's not to the defense.
Exactly, and the prosecutor often was thinking, you know what, I don't think that's helpful.
That's right.
This statement of a witness saying that he saw another person do it,
well, it's
which
almost,
is literally what happened once.
It's almost not fair, because you've got an adversarial system where the two sides are supposed to be advocating against each other. And then you say to the one side, but we're also going to give you the job of deciding what these folks on the defense part need to get.
And when to call the calendar and everything else.
That's right. So in North Carolina, about 10 years ago, we changed to what's called open file discovery, where we still don't have depositions, but we do have a right as defense attorneys to get a complete copy of an open file, if you will, of what the prosecutor has.
Right, which seems fair.
I think it does. I know the prosecutor that I worked for when I was a young cub coming up back in the early 90s, Don Jacobs down in Goldsboro in Kinston, even before the open file discovery law, he had an open file discovery policy.
Right, which makes sense.
He was a good enough trial lawyer, he could beat you either way,
right,
whether you knew or not what he had.
Right, and that way you don't have to worry about it coming out later that there was something you should have given the other side that didn't. And I do that in civil with the lower stakes. If somebody asks me for something and I think I could be cute, maybe object, maybe keep it away from them, maybe throw it in the round file, I always give it to them anyway.
That's right. It doesn't do anybody any good in a civil case or a criminal case. It doesn't do the prosecutor any good to have withheld some evidence that later should have been given over, or later is found that it should have been given over to the defense, because it just brings the conviction into question. And I think most prosecutors know that. And I can say that in my experience, most of the prosecutors I deal with are very forthcoming. They don't play hide the ball, especially in federal court now, although even in state court I've found that. But in federal court over the last 5 years, there have been a lot of abuses, not in North Carolina necessarily, but especially in that Ted Stevens prosecution in Alaska.
Yeah, that seemed awful.
And I have heard that the federal prosecutors have been read the Riot Act internally, and they've been told that they had better give to the defense everything, like you're saying, that might qualify reasonably as discovery that they need.
Right, because I think Ted Stevens, didn't he die before he was finally absolved and all that evidence came out?
I don't remember the exact sequence. I know he was kicked out of office. He was unelected. He lost the election because of the pending case.
Right.
And by the way, that's why Obamacare got passed, because if he had been alive, he never would have voted for it. But I stray. You're right. He passed away, and eventually there was a finding that the prosecutors had acted improperly. Just within the last couple of weeks, the Justice Department disciplined them. But from where I could sit, it was a slap on the wrist. They didn't lose their jobs. They lost pay for like 24 hours or a week or something crazy like that.
Depends which 24 hours in my biz, but but that can be an awful small amount of money.
561-8255, 561-TALK. If you have questions about the civil law for Don or questions about the criminal law for me, we invite you to give us a call at 561-8255. So, Don, in a civil case, you have a whole host of things you have to go through with discovery. You have written questions that can be sent from the other side to you that you have to answer. My favorite when I used to do civil law were always requests for admissions.
Right. You do get those too. I don't use those very much because I've found that you spend a lot of time coming up with them, and then the defense denies them. And then theoretically, if they do that improperly, you can then get attorney's fees later. But judges hate to award attorney's fees, and so you never get your attorney's fees ultimately, and you ended up wasting a bunch of time.
Request for admission being I send you something, let's say I've sued you in a civil case where I say that your client owes my client money, and I'll send you a piece of paper that says, admit or deny that your client is at fault. Admit or deny that your client is a bad person. Admit or deny. And you're supposed to answer those in good faith.
Yeah, which if you craft it correctly, you can do in the complaint anyway. Or you can, if they get cute in the complaint, you can always take their deposition and get them to admit it there.
When you file a complaint in the civil action, the other side has to respond specifically to each paragraph to admit or deny what you've put in there.
Correct. And a lot of times if you send out a request for admission, then they're sitting there in their office with their lawyer thinking up ways they can deny it. If I just hit them in the deposition, they're like, yeah, I do. And their lawyer's going, dang it. And then it's over.
So requests for admission strategically maybe aren't the best way to go, but in a civil case, you do have a lot of other things available to you.
Yeah, and they can be used, and I do use them. But yeah, you do that. You do what they call interrogatories, which are answers under oath. When you send written questions, they have to verify their answers under oath. You just get kind of basic information with those. Then you take your depositions, both of the parties and the people who were witnesses that may testify at trial. And then as the last stage, you would take expert depositions.
It's part of the reason we love the law. It's like an investigation. You get to be an investigator, you get to be a lawyer, you get to be everything. And tonight you get to be a radio show host.
Yeah, right. All three.
561-8255, 561-TALK. We've got Don holding on the line. Don, welcome to Call the Law.
Good evening, gentlemen.
Excellent name, by the way.
Thank you. I had a question about a credit card. In 2009, due to the economy, my job was pretty much null and void, and I was unemployed. I called the company to make arrangements to kind of reduce the payment. They refused, and therefore it was turned over to collection. I've been going around and around with several different collection agencies on it and trying to make good on it, but they want me to give them my bank account over the phone. And, you know, I tell them I'm not going to do that, but I'm willing to make good on the debt, but, you know, I'm not going to do it that route.
Yeah, I would.
And they're telling me that's the only way that they're going to do it.
Well, it puts you at a. There's an old saying. I don't even know where it comes from. It's called a Hobson's choice that we learned about in law school, where you've got two choices that really aren't all that fabulous. They obviously have a certain amount of leverage because you admit that you do owe the money and you just hit hard times, and that's why you got behind on your payments. So they start out with the proposition that they're owed the money. Then you get in a situation where they want your bank account number, which you are completely 1,000% justifiably not wanting to give to some stranger on the phone, and you've got two sort of not really ideal choices. You can tell them to go fly a kite or go pound sand, as Keith says. And if you do that, then you're liable to buy yourself a lawsuit. But on the flip side, if you give them your bank information, then they're liable to get more money than they're owed out of your bank account. And all in all, if I was in your position, I wouldn't give them the bank number, even knowing that a lawsuit may come. That gives me too much concern, and I certainly would. I would make them make their request in writing to you and tell them to in that phone conversation where you're telling them to make the request in writing, tell them to stop calling you and bothering you.
Well, they have sent me something in writing, but to contact them, I have to call a phone number.
Right.
And I tell them, mail me something where I can mail you a check. And they tell me, well, we got to have your bank account number first to get a check of good faith, so to speak, saying that I'm going to be making a payment. And I'm absolutely against it.
Yeah, and they're obviously concerned probably about a check bouncing, but there's ways to get around that. Like you can tell them, tell you what, why don't you give me your bank account information and I'll wire you the money, or you can get a money order, anything like that. So
I told them I'll give them a cashier's check directly from the bank.
Right, cashier's check.
I'm not giving them my bank account.
Yeah, so all of those things should put to bed their concerns. So, like I say, even though it's a risk that they then farm it out to a lawyer and you get a lawsuit, I wouldn't give it to them if I was you.
Is there a time limit on how long they can
3 years.
Keep trying to collect? How many years?
3. And
3.
If there's ways to extend that if they've got record of you acknowledging the debt, but normally a lawyer who gets a file, if it's post 3 years, he's going to break the news to them that he doesn't want to be messing with that thing, because lawyers don't really they get these very small credit card things and they want them to be clean and clear. And for example, at one point I represented a lending institution, and if something came through that was anything but just a complete admitted debt, they would pay me by the hour, and otherwise they'd pay me a flat fee. So if they're past 3 years, then they got a problem.
Well, July will be 3 years.
Yeah. So you could just be nice to them, say, yeah, I'll get you that info, and then see if that July, you don't have any affirmative obligation to advise them of what the statute of limitations is.
Well, the only concern I have is they keep tagging my credit report.
Yeah, and they'll do that. They'll do that. And
that's the threat that they make over the phone to me. Look, we don't get your bank account, we're going to keep tagging your credit every month. Right. And we're going to keep adding interest.
Right. And they do have to be careful with those threats. And neither Keith nor I really knows the federal law very well, but there are protections, and they can't threaten you, and they have to leave you alone once you tell them to do that.
Now, do I have to do that in writing, or can I tell them over the phone?
We've always, in the past, advised people to do it in writing just so you've got a record that you did it.
Okay, great. I'll try that.
Yeah.
All right,
Thank you so
Don.
much.
Appreciate you calling tonight.
Thank
Good
you.
luck, Don.
561-8255, 561-TALK. If you have questions about the civil law for Don or questions about the civil law or criminal law for me, 561-8255. Don referenced a Hobson's Choice, which I have looked up here on Google, which led me to Wikipedia. A Hobson's Choice is a free choice in which only one option is offered. Apparently, there was a man by the name of Thomas Hobson who back in the 1600s owned a stable in England, and people would come in to rent a horse for a while. Well, he had 40 horses, but they would always choose one or two that were the best, and he was concerned that those one or two would be overused. So people would come in, and he would say, you have your choice of horses. You can have this one or no horse.
Yeah, right.
And it became known as a Hobson's Choice.
Yeah, so so I was right. I did remember that, but I didn't know where it came from.
561-8255, 561-TALK. Questions about the civil law for Don, the criminal law for me. Don, we have a criminal law case in the news in Raleigh in the News and Observer.
I did not see. I did hear that old Jerry Sandusky's on trial at this point, but I didn't hear. I get all my news from ESPN.
Well, quick update then. There was a lady in Raleigh who got onto the Beltway apparently on I-440,
I did hear about
drove
that.
the wrong way.
Awful.
Led to a collision, or not a collision, somebody swerved to avoid them and a death. She allegedly had a .16, a 16 in her blood alcohol. She's not yet charged with murder, but I think she's pretty likely going to face a second-degree murder charge, not because she drove her car with the intent to kill anyone, but because second-degree murder is murder committed with malice, which can be defined as reckless and extreme disregard for human life. And there's a ton of case law from the North Carolina Appellate Court saying that if you drive drunk and it leads to the death of someone else, that's sufficient to say that you had malice in the sense that you acted with an extreme disregard for the lives of others.
Right. If it's her very first time, does she have any chance of them actually charging her with something less?
It depends. I think it depends somewhat on the discretion of the local prosecutors. I know in Raleigh they had a high-profile second-degree murder case like this involving a doctor.
And the ballerina.
And that was last year. And they actually tried that guy on second-degree murder, but the jury ended up finding him guilty of lesser charges, apparently finding there was no malice.
Right.
This is going to be a tougher case. Wrong way on the interstate,
Yeah, well,
5 miles, that's going to be a tough case.
there's no question that the negligence, the drinking combined with what her driving error was, is awful. But my theory would be that on your first go round, if you were taking pills and drinking and made a bad decision and got in there and were in an unfamiliar area and made a wrong turn, seems like second degree murder is just pretty harsh.
Yeah, I agree with that. And they may bring that charge, but sometimes they do that as a leverage point because then it could lead to a plea later on to some lesser charge.
Right.
And of course, as always, this woman is entitled to a presumption of innocence, so let's not jump to any conclusions. 561-8255, we've got people stacking up on the phone lines.
Wow.
Let's go first to Mike. Mike, welcome to Call the Law.
Hey guys, how are you doing this evening?
Good, Mike, how are you?
I'm doing well. Which one of you guys was playing the part of the announcer? I tell you, the announcer's in trouble. You guys are good. was that Don doing
No,
that?
that's Keith.
That's Keith. Okay, well that's pretty good. That was really, particularly on short notice. Here's my question. I have a mother that is cash poor and land rich. Okay, that's the setup. She's 75. And we were wondering how maybe we could, she's the sole survivor, maybe how we could protect some of that land from long-term care expenses, something like you just talked about with driving the wrong direction on an interstate, a liability suit.
Right. Regarding a liability suit, the best thing to do is make sure that she's got good insurance, which is very affordable for people her age, and you can get enough insurance to protect that land for what I think is a relatively small amount of premium.
Right.
Regarding other issues, there are attorneys, including locally, that practice in what they call elder law. So they can take you through planning for her everything in her entire estate and help you with all those issues, preserving Medicaid if that's one of the issues, or Medicare. And if you call my office at 757-7777, we can certainly give you a name, but neither Keith nor I has ever done that.
Okay. All right. Well, I do appreciate that. And that's 757-7777?
Yes, sir.
Wow, that's a lot of sevens.
It's also tonight's winning lottery number.
Keith loves to do that.
Okay. Thank you so much. I appreciate it, guys.
No problem.
561-8255, 561-TALK. We've got Celeste holding on the line. Celeste, welcome to Call the Law.
Thank you. I appreciate that. Thank you for taking my call.
Yes, ma'am. What can we do for you tonight, Celeste?
I have a quick question. I have evidence that my name was forged on a two-party check, and I have been told by the district attorney that there was nothing I could do about it. Wachovia at the time was transferring and going over to Wells Fargo, and they don't want to touch it, yet it was cashed in their office.
Okay, first, Celeste, we appreciate you calling. If you could turn down your radio, I think we're getting just a little feedback there.
Okay.
This is it's a good question, but it has a lot of layers to it. Criminally, if anyone uses your name and forges your name, that is a criminal offense. Whether it's large enough to be actually prosecuted in criminal court really depends. It would have to be a fairly big check, I would think. But done civilly, I know there'd be civil liability for the person who signed the check, but also perhaps for the bank that cashed it.
Yeah, civil liability is a definite, obviously, for the person who signs the check if they absconded with the money. The banks actually have some fairly solid protections. They actually, and this kind of surprised me. I got involved in a case like this, but I didn't get deeply involved in it, so I can't really take you chapter and verse through it, except to say that if it's a significant amount of money, it's worth.
It is.
It's worth.
It's over $20,000.
Yeah, well, then it's worth definitely taking it to a lawyer and having them go through the analysis in great detail. Because, yes, the bank definitely is potentially a target for cashing that check when they shouldn't have.
And Celeste, that's a large amount. I wonder if maybe all the facts weren't known to the prosecutor involved in the case. You may want to talk to a criminal lawyer in your area. I don't know if this is Pitt County or somewhere else, but maybe if you presented those facts to your own attorney and had your own attorney meet with the prosecutor's office, it might make a difference as far as what's done there, even on the criminal side.
Okay, it is in a totally different part of the state. I live in northeastern North Carolina, and it was done by my ex and his girlfriend in southeastern part of the state. And I have even called the sheriff, and they said it's not their jurisdiction. And the conversation has been coming from the district attorney in southeastern North Carolina. And I was told, well, just things happen. You just have to get over it.
You need a lawyer in that state, in that county, because you're out of county. You don't really matter apparently to the folks down there. You need to get a lawyer down there. Pay them $500 to try to make your presentation to that DA, and you might be surprised how much further it gets. All right.
I had already got. Thank you. I appreciate that very
Thanks,
much.
Celeste.
Good luck, Celeste.
561-8255, 561-TALK. This is great, Don. We got the calls rolling in tonight.
Yeah, we're going to have to, it's going to be like the sports shows where people are going to be dropping off. And
That's right. We've got Scott holding on the line. Scott, welcome to Call the Law.
How you doing? Appreciate you taking my call.
Yes, sir.
I was had a charge on like 5 or 6, but they were, felony charges back in college in like 97, where somebody stole some money out of a store and included me into it. Long story short, there was 3 or 4 embezzlement charges or whatever, and coming out in court, which I proved my innocence, so it was dismissed. The thing about it is it still remains as a charge and dismissal, which after college now and the company going bankrupt that I was with, and then finally going and getting a new job, I thought it's now starting to be a little hassle because it's showing up and I'm having to explain things, and I can't really explain things because even the records have been destroyed. When I go to the county clerk's office showing everything, all I can show is a mumbo jumbo that people can't understand, which it says DD, and they really don't understand what that means on these papers that I got.
Right,
So
Scott.
I understand about getting an expungement, but I'm seeing that it's $500 and $600 for expungement. Is that the only route to be able to go to get that off?
Yes. That's a short answer to your question. That's why expungements were designed. They were designed for situations like this, where you have a dismissed charge, you've been found not guilty, certain other categories of charges that maybe were youthful mistakes, and you don't want to have to explain them forever. Back when Don and I were coming through college 20, 30 years ago, this kind of stuff didn't matter because nobody could know what we did or did not do. And I'm not conceding anything, Don, at least not for me.
I'm not either.
But today, in the day and age of the internet, everybody could check your record wherever. It's all tied together. Yeah, you should spend the money on an expungement. If you have multiple felony charges and somebody's telling you $500 or $600 for an expungement of those, that's cheap. I'll be honest with you. I wouldn't do it for that. And that's something that I think you'll see more than a benefit, more than a financial benefit that comes back to you far in excess of anything you spend on the legal fees.
Right. Well, I mean, I just think if it's final pay, I just don't. Is it a long process? I mean, I just don't get. You know, hey, it's been dismissed. I just don't see $600 to get that. But I guess.
Well, you can keep on like you are if you want to, but yeah, it is kind of a long process.
Does it ever fall? Well, I got the job because I was able to explain it, but I just don't want further problems. Does it ever drop off of there?
It does not. It stays there as a dismissal, not as a conviction. The process is that you apply for the expungement and a background check is done to see whether you've used expungements before and to see if you have any felony convictions, not charges, but convictions on your record. If you meet those conditions, then the background check is returned from Raleigh. It takes them about 4 months, depending on their backlog. And after that, the judge will sign an order that expunges the case. And your attorney should do some follow-up to be sure that it's actually processed as it should be and removed from all the computers. But the short answer is, unfortunately, yes. It's difficult, it's frustrating, you got to spend some money, but it's going to be money that's well spent and well invested in your case.
So the $500 to $600 is reasonable?
In my opinion, it is. I can't give you legal advice over the phone and certainly not quoting somebody else's fees over the phone, but general ballpark of what I understand to be fees for that, I think that's reasonable.
All right. Is there any chance that I could go back and have a civil suit against the person that lied?
Sure, go right ahead, but you're going to have to spend a lot of money on somebody like Don and probably not get much to show for it.
Yeah, unfortunately, usually people that do stuff like that don't accumulate much in the way of assets, but absolutely they are responsible legally, and you could get a judgment against them.
If anything runs like this in the future, things like that, it's just weary to know that somebody can do that and it'll remain on there. Is there any chance that later on in life or my children's life, if that happens to them, are they supposed to say, hey, Judge, I want this completely off my record when they're in court? Or
Nope, there's nothing you can do about that. It's only the expungement.
Wow.
Scott, we got to let you go. Yeah.
Appreciate it.
Thanks for your call, man. 561-8255. We've got Carolyn. She's going to have to be our last caller tonight. Carolyn, we got about 2 minutes for you. Thanks for calling.
My question is simple. To get an annulment for marriage or divorce, whether a person files for it themselves or go through an attorney, do you have to show before the courts to make it legal?
Wow, they stumped us on this last question.
Wow.
Never had an annulment question. Neither Keith nor I have practiced in the area of domestic law, which is what you're asking about, for quite some time. But I would think that...
I know some people get the papers themselves. They go to the courthouse and get the papers themselves. But I would think that to make it legal, you would still have to go before a judge or something. Somebody have to say, yes, I grant you this divorce, or I don't grant you this divorce.
Yeah, I mean, that is my knee-jerk, but theoretically, you could, with an annulment, which is a more simple process, and I'm getting the answer now. It's coming through to me. Yeah, you do have to get a court order so that annulment becomes quote-unquote official and shows up on the records. Otherwise, they're going to have, records that show that they're married, short of that.
Okay.
Carolyn, we're looking at a website from the Rosen Law Firm, a divorce attorney in Raleigh, and that's exactly what he says. But we would strongly suggest you consult with a domestic attorney because you're going to need somebody experienced in that area. Sort of like our last caller, it's going to be worth the investment. And as one of our district court judges, Charles Vincent, likes to say, you can represent yourself. You could also take out your own appendix, but you might be better pleased with the results if you have a professional help you with it.
Okay. All right.
Good luck.
Thank you.
Hey, thanks to everyone in our radio and TV audience for watching and listening. That brings us to the end of another great show here on Call the Law. We hope you have a great week, and we'll see you again next Tuesday night here on Call the Law.
brought to you by Keith Williams from the law offices of Keith A. Williams, online at williamslawonline.com. And by Don Higley of the Lanier Law Group, online at lanierlawgroup.com.